Hi, this is attorney Jeremy Hogan, and today on Legal Briefs, we talk about the first defense in any foreclosure action. Show me the promissory note.
Show me the money. That's it, brother, but you got to yell that shit. Show me the money. I need to feel you, Jerry. Show me the money. Jerry, you better yell. Show me the money.
If you are facing foreclosure, today we are going to give you a Legal Briefs overview of one defense you must raise. Show me the money. Show me the promissory note. This is actually a very interesting issue for anyone with a home loan, even if you aren't being foreclosed, and one you absolutely have to understand if you are going to fight to keep your home. Let's assume that hard times have fallen on you and you missed mortgage payments and the bank is foreclosing on your home. I often hear people think of this as a black and white type of situation. You think, I missed payments, they're going to take my home. It's not that simple. When we talk about fighting foreclosure, 95% of the time we are talking about making things difficult for the bank so that the bank will come to the table and negotiate a loan modification or some other means of allowing you to keep in the home. This often works, but what I can guarantee you is that if you do nothing, the bank will move forward, and eventually this is what happens. And when I mean what happens, men and women with guns come to your home and you have just a couple of hours to pack up. This is what it looks like. Don't be that guy. What you think of as your mortgage is actually two separate legal documents, the promissory note and the mortgage. The note is the promise you made to repay the money that you borrowed from the bank, and the mortgage is what attaches your home to the note. The note alone means you owe the money to the bank, but the mortgage is what allows the bank to take your home and sell it in order to pay back the money you owe them. Remember this fact with my simple joke: why is a mortgage always attached to a note? Because it doesn't want to be a loan. Get it? A loan. Remember that joke because it will be very important soon. I bought my house 4 years ago. I signed a note and a mortgage with Bank A. Literally 2 weeks after closing, I received a notice from Bank B that it had purchased my loan and that I needed to start paying back Bank B. In fact, your note can be sold 10 times while you own the home, and legally there's nothing wrong with that. It's not illegal. However, in more recent history, things have gotten even more complicated as various notes from various homes have been packaged together and sold to investors. The system is so complicated now that there's really like only one lady in all of the country who truly understands how it all works, and I'm not even joking about that. Often, the loan has been sold that many times without you even knowing about it. But you signed only one note originally, and when some entity calling itself MERS shows up foreclosing on your home, how do you know, or how does a court know, that the entity foreclosing on you actually owns the note? The general idea of the show me the note defense is that the bank foreclosing or the entity foreclosing on your home must show a chain of custody from the original note that you signed often years ago all the way down to the current note being foreclosed on. Every time the note is sold, there must be an assignment of the note and the mortgage to the new bank or whatever it is that is buying the loan. Think of it like a football trick play with multiple laterals of the ball. Every time a player hands the note off to another player, there has to be a signed document. Football makes everything cool. So in our football video example, there were 8 lateral transfers of your note, and the bank would have to bring to court 8 different assignments signed by all the relevant parties in order to prove the chain of custody. The bank can't just show up with the final transfer from Bank 7 to itself and run into the foreclosure touchdown. It has to prove all the prior transfers leading back to the one you originally signed with bank number 1 years ago. But these are large, big banks, they're big companies. We have to trust that they're not going to commit fraud, right? They would never commit fraud or do anything unethical, right? Right. So, I'm not going to go into it in this video, but just Google mortgage robo-signing scandal and you'll see why we have to make the banks prove they are the proper party handling the note. So practically speaking, how do you raise the show me the note defense? Be careful. Courts have been making the defense more and more difficult to raise. In U.S. Bank N.A. v. Nelson from 2019, the New York Appellate Court held that it was not enough to simply deny that the bank was the holder of the note. The defendant homeowner had to raise the issue as an affirmative defense. And this is the general movement of the courts on this issue recently. The defendant homeowner is being placed more and more in the position of having to somehow shift the burden of proof to the banks to prove what really should be the bank's burden. It's an unfortunate shifting of the burden of proof in my opinion, but it is happening out there, so be careful. Likewise, The general rule in the past has been that the bank would have to be in possession of the original signed note in order to foreclose, but more recently, courts have been allowing banks to get away with lost note affidavits in which someone at the bank swears under oath that they had it, but they somehow misplaced it. Again, an unfortunate shift in judicial opinion, but the banks still have to prove a clear chain of title up to the present day. See Hines v. New Urban Pine Road, which is a 2018 case out of Florida. This is a big deal because it's the easiest thing in the world for your mortgage docs to be copied and digitized nowadays. There's probably 1,000 copies of your loan docs floating around out there in the other somewhere. How can a court know who the true holder is or make sure that there wasn't a mistake? Well, the sad truth is that some courts have just made a decision that they are going to give a pass to the banks and take them at their word. And here's the walk of shame, the states which allow people's homes to be taken away based on trusting the bank. Arizona, California, Idaho, Minnesota, shame on you. If you want to see some crazy jurisprudence, take a look at Hogan, no relation, v. Washington Mutual Bank. Basically, the court said that because the legislature didn't require proof of the chain of custody, it was going to throw out everything lawyers are taught in evidence class the first year of law school. It was a stunning abdication of judicial duties, but anyways, I better not say any more. I'm going to get in trouble. Okay, so I hope now you have a general understanding of what the Show Me the Note defense is all about. But it's just one defense of many, and I hope in part 2 of this video to talk to you about truth in lending and other technical violations you might be able to raise in your fight to keep your home. Best of luck, and thanks for watching.